Good afternoon, everybody, and welcome to the District of Columbia Court of Appeals. We have one case before us this afternoon. It's an emergency juvenile detention appeal. It is 25 FS 929 in re J.R.R. Whenever you're ready, counsel.
Good afternoon, Sarah McDonald on behalf of Appellant J.R. I'd like to reserve 3 minutes for rebuttal. 13-year-old J.R. is currently detained in contravention of due process and the statutory limits on predisposition detention of children. Before I address the two independent reasons why J.R. is not detainable, I want to briefly clear up some confusion about the ripeness and timing of this appeal. The government's argument is that this court cannot evaluate the lawfulness of J.R.'s detention until Judge Willoughby issues the written order on the motion for review that he said on Friday he would issue within the week. But nothing in any statute or court rule required Judge Willoughby to issue a written decision. And in fact, Judge Willoughby issued an order this morning holding the written decision in abeyance in light of this appeal. This court can and should address the legal questions about J.R.'s detainability now, and there is no need to ping-pong this around from court to court while a young child remains unlawfully detained.
Do you think that his comments about I'm sorry, I completely forgot what I was going to say. Never mind.
I think some of the confusion here comes from the government's attempt to paint the question of detainability as a matter of discretion, but it's a question of evidentiary sufficiency. And so when Judge Willoughby determined on Friday, after hearing the parties' arguments on the undisputed facts about whether J.R. could be detained, when he determined that J.R. was detainable, citing his abscondances, school absences.
I think that's the question, right? Sorry to cut you off, but that's the question that seemed, we had the ability, luckily this morning, thanks to our great staff here to hear the recording. And it seemed to me, at least, that the references to abscondance and those issues were sort of an aside at the end of the hearing by Judge Willoughby. Prior to that, he said multiple times, I'm not going to issue my ruling at this time. I don't have enough information, separate and apart from any ruling that I'm going to issue next week. I'm going to step him down to a shelter house. Now, we can talk about legally whether stepping him down is an actual event that becomes reviewable in this court, but it does seem to me that Judge Willoughby was clearly indicating that he had not decided the merits, and whether there's a statutory hook or not for this, isn't it, in our best interest as a court, an appellate court, to wait to see what he has to say?
So I will say first, I have not yet had the opportunity. I haven't been provided with transcripts, and so I have not seen them. I don't disagree that Judge Willoughby did say that he was reserving ruling, as we argued in our opposition and reply. I think that, in fact, he has to be understood as reviewing the magistrate's decision, especially because of what he said when he was asked the basis for his decision. Those things sounded in reasons to detain, not reasons that YSC wasn't appropriate as opposed to shelter house. And so I think that has to be because there's no requirement that he issue this written decision or order that he thought he had to make. I think he completed the review, even though we agree that he was expressing his understanding.
But is that because he did step J.R.R. down to shelter house, and then, which I think technically required the separate order that he issued, which perhaps as a technical matter confers jurisdiction in this court. But putting that aside, let's say Judge Willoughby had said, I'm reserving ruling, I will be issuing a written ruling next week, everything that he pretty much said, and then said, have a good weekend, everyone, go home, and said nothing about stepping him down to the shelter house, and then didn't issue a ruling. So I guess two questions. Would that have been permissible as a timing matter from your perspective under the statute? And number two, if that had happened, would we have jurisdiction?
I do think, not to fight the question, but I do think that's not what happened, because the parties agreed that Judge Willoughby could issue an independent ruling on detention, and that's what he did. And the government says that there's no grounds under 2328 for that purported independent ruling on detention to be appealable. But I think that can't be right. That was the first time that an associate judge addressed the question of detainability. And the government agrees that, we couldn't appeal just from the magistrate judges.
But is the idea that just he's doing two things? He says, he makes these comments separate and apart, and he responds to questions. What is the basis for this? I mean, are these the kind of things that you're basing your conclusion on, that he's detaining him? He's also apparently not detaining, he's apparently doing something else that he's going to talk about later next week. But is it the separate and apart that is key?
As I think we argued in the opposition and reply, I think there are two ways to look at it. There's a way to view him doing two separate things. He's making this independent decision on detention, and then he's reviewing the magistrate's reasons for detention. If that's the world we're in, then I think the proper course is just to, the pending motion, to the extent it's still there, can be dismissed as moot. And this court can evaluate the independent detention decision that Judge Willoughby made on October 10th. Or the other possibility, I think the government has tried to sort of frame this as reconsideration, which doesn't fall within 2328, but an associate judge doesn't reconsider a magistrate's order. So the other explanation for what Judge Willoughby was doing on October 10th is that he was reviewing Magistrate Judge Jones's order, and he thought that as part of that review, he had an obligation to issue this written order, but
Isn't
he
that
did not.
correct?
Well, in
under the
effect,
statute?
I wonder if it would be correct to think of it this way. In effect, you go into court and you say to Judge Willoughby, we want our client released right now. Today, we want him to walk out of here. We don't want his detention to continue one more minute. And the judge says, no, I'm going to continue it one more minute. In fact, I'm going to continue it a week. And then I'll decide whether I continue it for more than a week. If you think of it that way, then isn't that a situation where the judge has made an order detaining or continuing the detention of your child sufficient to support jurisdiction on appeal?
Yes.
So that's how I've been thinking of it. And I wonder if you think that's correct, and now the government will tell me later why it's not correct, but do you think that's a fair way to look at it?
I think that's a fair way to look at it. And I actually think that this court's decision in KH, which is one of the things that the government is relying on in saying that this court can address this appeal and that it does not fall on 2328, is KH, which says motions for a decision on reconsideration does not fall within 2328. It's still clearly an appealable order over which this court has jurisdiction, but it doesn't fall within 2328. And that's because of a judicial economy point. The court in KH says if every time someone sought reconsideration, which they could do over and over and over again, and every time that was denied, we could be hauled in here on an emergency appeal, that's very inefficient. Here, I think we have the opposite problem. The government's argument is that this appeal isn't ripe until we get this formal written decision. If we wait for that, we will be back here in court on these same briefs, making these same legal arguments, which present pure questions of law.
But anytime an associate judge or in any analogous situation, a reviewing judge says, I'm deferring decision or I'm withholding decision at this moment, put aside here the step down for a moment. So status quo remains in place, which it necessarily would if there's a reservation of decision. Then that can always, to take Judge Glickman's question, always be characterized as a renewed decision to detain, but it can also be characterized as just retaining the status quo, which in that situation, they're the same thing, but that can't necessarily confer jurisdiction on this court to review simply because the status quo remains, which is in effect a continued detention of your client, right?
But KH does hold, based on an earlier decision in DJ, that there is jurisdiction in those circumstances. So if a client has sought reconsideration from an associate judge's order of detention, and that reconsideration is denied, the client says either my detention was never founded to begin with, or says circumstances have changed and I should now no longer be detained. That is under KH an appealable decision. It does not fall under 2328, but the court still has jurisdiction and it's still appealable, even if the judge denies the motion for reconsideration by maintaining the status quo.
See, I must say, I don't think it's fair to call the government's position one of reconsideration. I think the government's side of that. I mean, suppose you go into court before the judge and you say, Judge, here's what we want. We want our client released from detention. And the judge says, okay, I'm thinking about it. I'm thinking about it. You may be right. You may be wrong. I'll call you. I'll get back to you. Now, do you think that if that's what the judge says and doesn't get back to you immediately, you can appeal? Or do you have to say, okay, Judge, we'll let you think and tell us what you conclude before we can appeal?
I think in the world.
That's what I think the judge thought he was doing.
Well, I think both, I'll go back to my point that the parties both agreed that Judge Willoughby could make an independent ruling on detention, and that's what I think he saw himself as doing. But setting that aside, I think in the world of detained children, the council has made very clear the desire for due process, the desire to have prompt reviewability, and that's why the provisions for review of a magistrate's order set a maximum 48-hour window for an associate judge to review a magistrate's question of detention. So I don't think this is the kind of review, the kind of thing that can be pushed indefinitely. And that is clear just by analogy to the interlocutory appeal procedures in this court. Like if Judge Willoughby can give himself longer to decide this question of detention than this court can have, I think there's a problem there. And I think that this court has held in KG, and it's clear from the statutes that to the extent there is ambiguity in any procedures, we construe DC Code Section 162328 in favor of, in light of the council's desire for due process and prompt review. And this court should do that here. We do have an order that falls under 2328. This court is presented with pure questions of law. And to Judge Shanker's earlier question about would it be beneficial to have this ruling coming from Judge Willoughby on detention, I think we've pointed the court to RO. I think that's an example of, in the ordinary course, we would remand maybe for the trial court to give all of their reasons. But when what is at stake is a detained child, there is no reason to follow that course.
Can I ask you, can you clear up something that I probably shouldn't be confused about, but I am now that you mentioned KG, which is KG, I think, says something along the lines of shelter care is not detention. Is that just wrong? Or, here we're dealing with an order to go to shelter care, right?
That's just wrong is my position there.
Okay.
And the government agrees, everyone here agrees that J.R. is still detained.
Okay.
And the reasons that Judge Willoughby gave for J.R.'s detainability, again, our abscondence, our school absences, are this failure to charge the GPS monitor. And those are not reasons. Those reasons sound in 2310A2, but 2310A2 is strictly limited. It permits detention only when it is required to secure the presence of the child at the next court hearing. J.R. is an extremely young child with at least 2 diagnoses, and he has consistently appeared in court every single time he has been asked to be in court, including when he knew that the purpose of the court hearing was to seek his detention.
Now, where do you consider the standard of review to be when we're looking at what the judge is saying and the kinds of things he's saying about that you assume have something to do with him showing up to court, the abscondances and whatnot? Is it discretionary?
The standard of review, as is clear from KG, is de novo. The question whether the statutory criteria are met is a question of sufficiency of the evidence. And like other sufficiency questions, it's reviewed de novo. And KG also makes clear it's the government's burden to establish a child's detainability. And that burden is by clear and convincing evidence. That's not expressly KG, but in the adult context and in other cases such as DM, this court has analogized to the clear and convincing standard. So the government had the burden here to establish that J.R.'s presence, that detention was required to secure J.R.'s presence at the next court hearing, and nothing in the record here can meet that
So
burden.
every time one of these questions arises, there's a right answer and a wrong answer. There's no like kind of, looking at all the different factors, and there's discretion doesn't come into it. It's like doing a regular sufficiency challenge to a conviction.
Correct. It's a sufficiency question. And so I think that's another reason that there's no reason for this court to wait for Judge Willoughby's ruling.
Well, it's it's a sufficiency question, but to answer that question, the judge has to make some judgments about the significance of J.R.'s behavior leading up to the hearing. And that behavior, the judge could fairly say, I think, hardly gives one confidence that he will show up at a future court hearing. He's absconded, he's unreliable, the police had to go out and find him. They only found him because his ankle monitor, GPS monitor was working. If he had to show up for court the day they found him, I forget where it was exactly they found him, but in some abandoned building or something like that. It's hard to believe he would have shown up. How would he have even known what day it was? It seems to me understandable, at least, why the trial judge would look at those facts and think, I have a real concern about whether J.R. is going to, can be relied upon to show up in court at his next hearing. And that was the rationale that the judge gave, if I understood what he said correctly.
I think it's purely speculative to say that he would not have showed up. And I think what the total
Is any
picture
prediction
of,
about the future is can be subject to that kind of, challenge, but
sure. I think that the full picture here, though, is that, JR has a team that makes sure he gets to court. And these other
well, if you
issues
were his
that come-
attorney in the trial court, let's say you're part of that team, and his mother calls you and says, I can't find J.R. I don't know, we've been looking for him for days and I don't know where he is. And you don't have access to his ankle bracelet. That's going to tell you, where he is. He's got a nice team on his side, but I don't know if that team would have been able to find him and bring him to court under those circumstances. What do you think?
I think looking at the factors under Rule 106, like it's true that abscondances can be taken into account, right? But I think that when you couple that with the other factors that are here, like the length of someone's ties to the district, their level of connection to the district, whether they reside in the district, we're thinking about abscondence sort of more in the way we would think about it in adult court, right? The only things that the detention criteria are concerned with are securing the person's presence in court. So I think it's fair to say that yes, the statute is concerned about abscondence, but it would be a different scenario, if we're talking about a 17, 18-year-old who had bought a one-way ticket to Venezuela. I think what JR is engaging in here is ordinary childlike behavior of running away from home. He's not absconding from the district. He's not trying to flee the jurisdiction to avoid court. He's engaging in childlike behavior of running from home that has been explained by a diagnosis that he has just recently gotten. And the council has made clear that ordinary childlike misbehavior, that non-compliance is not a basis.
How long had he been gone when the police finally, the police, right, finally found him? How long, do I remember that correctly?
So the police found him on September 30th is, I believe, the incident that Your Honor is referring to.
How
and
long
he
had he
left
been-
home the day before on September 29th. So the custody order was issued on September 30th, but it was mentioning an abscondence on the 29th. And again, I think the court's reasoning really sounds in non-compliance and in JR's needs, but in the pretrial posture, this is a child who has not been adjudicated delinquent. In the pretrial posture, the only thing to look at is the risk of not coming to court. And there's a burden that the government has to meet here. And in the face of the evidence of JR consistently coming to court, these other issues of non-compliance, of abscondence, just can't show that JR won't make it to the next court hearing when there is every indication that he has and he will.
So counsel, your argument now is that, am I right, that it's premised, and I'm not saying you're waiving other arguments, but your argument right now is premised on the notion that there was a valid tampering charge with supported by probable cause. And it is premised on that assumption, right? And that even under that assumption, the two factors under 2310 were not satisfied here. Is that right?
That's correct, Your Honor. I
What
think,
you're saying right now.
right,
Okay.
that there are two independent bases that J.R. is not detainable. And I think that the 2310 basis is sort of the most legally straightforward one, that there is insufficient evidence that detention was necessary to secure J.R.'s presence.
And so why
yes.
is that? I mean, I have the same question, but why is that more legally understandable as opposed to there was no probable cause? The court had already said no probable cause for the UUV charge.
That is also an independent basis. It's clear, and the government does not dispute that a probable cause is a prerequisite for detention. A child cannot be detained without probable cause. And I think the analogy to the adult context here is telling, right? In adult court, if there had been a finding of no probable cause, the case would have ended immediately.
So what is different? I'm revealing my ignorance here, but why is that not the case in juvenile court?
I believe, Your Honor, it's because there's no grand jury in juvenile court. And so the petition can remain, but the court's ability to impose conditions ends at that point. And the court's only continuing interaction with the child is ensuring legally, lawfully, should be ensuring that the child shows up to court. Ultimate adjudication can happen, but when detention is off the table, which it is as soon as there's a judicial finding of no probable cause, the child initially agrees to release conditions, as a condition of their potential detainability. So when detention is still possible, conditions can be imposed, but once the child is no longer potentially detainable, this agreement, which the court discussed in KB, that these release conditions are an agreement between the court and the child on pain of detention, it
So
became
the
clear.
petition stays alive because it's not like adult, there's still, is it because you just need to still get to the adjudication, or is it because there are still services that need to be offered? Okay, it's just like, so what went wrong here? Was it, what should have happened when the no probable cause order issued?
So when the no probable cause order issued, J.R. lawfully was not subject to conditions of release. And so the entire basis, the premise of the tampering charge is for failure to charge the GPS monitor. But the tampering statute requires that the person be required to wear that. And J.R. was not required.
Right,
to
but I
wear
think
it.
the question was, not to speak for Judge Beckwith, but I think the question was, why wasn't that raised at the minute the court announced no probable cause as to the UUV charge? Why didn't JR's counsel say, okay, we're not going to agree to any required condition of GPS monitoring?
Frankly, Your Honor, I think it's because a no probable cause finding is essentially unheard of in juvenile court. And I think it can't affect the question whether the tampering petition, our argument is that there can be no probable cause on the tampering petition because it fails to charge an offense.
Well, it
Steve,
could, sorry, go ahead.
Well, you see, I sort of think about this part of the same way you do, but at the end I differ. So let's go through that. I do tend to agree with you that once the judge found no probable cause had been shown for the UUV charge, then that doesn't make the charge go away, but it does mean that the court cannot detain J.R. on that charge. And I think it does mean that it was not proper for the court to maintain the requirement of GPS monitoring. Nonetheless, the court did so. It maintained that requirement, and J.R. and his counsel did not object to it and did not say we want out from this requirement. That may be because the judge would have said, oh, okay, well, if that's the way you feel, we'll continue the probable cause hearing and give the government more time. Maybe they would, who knows what the judge would have said. In any event, but then we get the tampering charge. And one way of looking at it is that he was required, J.R. was required by a court order that had not been overturned or even challenged by J.R. to wear the GPS monitoring bracelet. And much to my amazement, merely not charging the bracelet constitutes tampering under the statute. So I don't think anybody's disputing that the judge properly or could find that there was probable cause to believe that J.R. intentionally did not charge the or recharge the monitor, and therefore probable cause to believe he had violated the statute. If you think of it that way, you know, what's wrong with what the judge did? The judge said you were required to wear this. Maybe that requirement should not have been imposed under the law, but it was, and you accepted it, and you didn't object to it. And after you were required to wear that bracelet, you tampered with it. There's probable cause to believe that, so I'm entitled to now, based on your violation of that statute, the two cases have been consolidated for hearing. The UUV case and but by this time they're it's one hearing for both of them. But I'm going to hold you, detain you or whatever I impose because of your violation of that statute, as well as the other factors that I've been considering. That's the question in my mind. Why is that not the right way to look at it?
I think both because of the word required in the tampering statute and because of the way that conditions work in juvenile court. And so that's why we've pointed the court to QB, is because unlike in the adult context, a condition of release in juvenile court is not an independent freestanding requirement. It cannot be. QB holds that unlike in adult court, a child cannot be charged with contempt for violating a release condition because it is just this agreement between the court and the child on pain of the child's detention. I am potentially detainable. I agree to abide by these conditions on pain of detention. Once J.R. again was found by a judge not detainable because there was no probable cause, that agreement dissipated. And so I don't disagree that the release order sort of remained on the record, but it's not fair to say that J.R. was required at that point to abide by it because the agreement, again, dissipated on August 27th.
So
Well,
is
you
it,
said, no, go ahead.
well, is it your position then that J.R.R. could have gotten home and said, wait a tick, I should have never been required to wear this. I'm cutting it off and throwing it in the trash can. And that would have been fine.
My argument would be that that would not constitute a violation of the tampering statute because he wasn't required to wear it legally at that point.
Well, it's sort of interesting, isn't it? There's two ways that the word required can be interpreted. So one might fairly accuse us with playing with, words here, but judges often issue orders to people. You have to do this or you can't do that. And while that order remains in effect, people are expected to obey it. And it's certainly true that sometimes the judges make mistakes. They shouldn't have issued that order. But I don't think the person can simply look at the judge and say, well, you've issued that order, but you're just plain wrong, so I'm going to disobey it. Now the person might get away with it in the end, perhaps, but it does seem a little odd to me. And you don't cite any cases in your brief, your interpretation of the word required in that statute. The government doesn't really respond to this in its brief, but this has been sort of point that's bothered me.
Right. Again, I think I would start again with QB, right? That these conditions of release are not an order free, like that has freestanding force requiring someone to do that independently. That's why a child cannot be charged with contempt under the contempt statute or the Title 11 contempt powers for violating a condition of release. I also think it's telling. I think it has to be the case that required in the tampering statute means lawfully required. I think there are, by analogy to other statutes,
Well, let me
the,
give you an analogy. Suppose it's a case of protection of a woman who's filed an interfamily action. And the judge issues an order, Mr. So-and-so, you must stay away from the complainant. Don't come within 100 feet of her. And eventually it's the person who violates that order. The person, comes within 100 feet. And can the person then avoid any sort of penalty by saying, well, the order was improper, the judge didn't have jurisdiction over me? Is that, I mean,
I think not to beat a dead horse, but that's why I keep going back to QB, is because that would be a freestanding order that can be enforced. The way to enforce that would be through contempt. And it's clear that
what do you mean
whether or not.
freestanding?
So QB says that a condition of release, a release condition, is not an order in the ordinary sense of that word that is enforceable through the contempt power. Instead, in the juvenile context, a release condition is this agreement between the child and the court. And so I think the fact that QB says, this is not an order enforceable through the contempt provision, it's this agreement between the child, makes this of a different kind. And on the point about,
But that's funny, isn't it? So what happens if the child disobeys it? Suppose it was a valid order. So suppose it was a valid condition.
then the child could be detained. That's how it ordinarily works. And that's why the detention, that's why the probable cause hearing on August 27th was held, because the government's position was J.R. was violating his conditions of release. So the clear procedure in juvenile court is at that point you hold a detention hearing. The government sought a detention hearing to try to say, we're going to revoke these release conditions. We're revoking this agreement and detaining you. But then J.R. was found undetainable.
But bear in mind that what's happened is that there's a new charge against the child that's come up that supports, namely the tampering charge, that supports and it's the probable cause for violating that charge that supports the detention.
Sure, but I'm saying, as to the answer for what is the consequence for violating a condition of release, the consequence for violating a condition of release is detention. So on the UUV charges, which is when detention was sought, that's the probable cause hearing on August 27th. When there was the finding of no probable cause, J.R. became undisputedly not detainable in the UUV case. It's sort of this separate problem that then J.R. is charged with tampering. But again, my position is the tampering petition does not charge an offense, because given that J.R. was not required to wear the device, because this agreement had ended upon the no probable cause finding, he was not required under the tampering statute, and there is no probable cause to hold him for any offense.
But it's your position that we, under your argument, wouldn't need to reach this question and could assume that there was probable cause for a tampering charge, but still no basis under 2310 to order detention at that point.
Yeah, my argument is that they're
insufficient evidence of the two factors of 2310.
correct, that they're two independent and independently sufficient for summary reversal, that they're two independent bases, that J.R. is not legally detainable. So for those reasons, we would ask the court to summarily reverse pursuant to the timelines in 2328. Thank you.
Thank you, Ms. McDonald. We will give you some time for rebuttal. We'll hear from the government.
Good afternoon. May it please the court. Jeremy Girton for the District of Columbia. I'd like to start with the jurisdictional issue where the court began. And I think our disagreement essentially is about whether Judge Willoughby issued any kind of decision on Friday, October 10th. And in our view, he didn't for several reasons. The first, I think, is because of the way he characterized what he was doing. And I'm glad that the court has had a chance to listen to the hearing. But also the decision he issued this morning stating that he was holding the motion in abeyance, I think only confirms that he didn't feel like he had issued any sort of decision yet and that he was still waiting to do that. So in our view, there simply isn't an associate judge decision for this court to
I thought
review
you
yet.
might think it went the other way because he sort of refers to this appeal being up here and uses the word interlocutory, and it makes it seem like there are two separate things going on.
Well, I think the word interlocutory is just how we describe the kind of appeals of detention proceedings. They're always kind of described as interlocutory appeals. I think that's the heading of the section. But I think what he is, the way I would read that opinion or that order is that he thinks he no longer has jurisdiction to decide his review of the magistrate judge's
Do
detention.
we know if his order was, had effect, the switch from YSC to shelter care?
I guess I don't know for sure, but I have no reason to think it wouldn't have been complied with immediately.
So, Mr. Girton, Judge Glickman asked a question to Ms. McDonald in one direction, which is if Judge Willoughby had asked for 5 minutes to think about this issue without deciding it, could J.R.R. have brought an interlocutory appeal at that moment? I guess I would ask the question at the other end of the spectrum, if Judge Willoughby had said, I'm going to decide this in a month. Is it and retain the status quo, let's put aside any step down or any change in circumstances, that there would be no appeal by J.R.R. and he would have to be detained on the magistrate judge's order that entire time?
I think if the judge said, I'm not issuing a decision and I'll do so in a month, I mean, J.R.R. might have some other avenues toward like a mandamus petition to direct the judge to issue a decision, but I still don't think the judge has made a decision in that case because the status quo just remains. Otherwise, I think to Judge Glickman's hypothetical, every time the defendant's counsel says, we'd like you to reconsider detention, we would like him released, and the court says, I'll think about it, that somehow transforms into an appealable decision when the judge has made clear that he or she isn't actually deciding anything, they're just considering the request. And so I think that's what happened here. I think Judge Willoughby essentially said, I'm going to make my decision next week. I'm going to, provide some reasons in writing. And by operation of not deciding, the detention remains in place. And if you look at the order that issued immediately after the hearing, which is the first attachment to their motion to this court, it says order for return to custody pursuant to a prior order. So it seems to establish the basis of the detention as the prior magistrate judge's order. And then this form has none of the information you would normally see in a decision on detention.
What do you think he's doing when he is asked by defense counsel to provide the bases for his order and he said he answers?
So the question was presented to him as the basis for the step down. And I agree it's a little bit strange and it's not entirely clear exactly what he was referring to there. But I think it was more of an aside, as Judge Schenker described it earlier. He obviously was expressing concerns about J.R.R.'s future appearance at court hearings. I think that's obviously a concern that both the magistrate judge and Judge Willoughby had. But I don't think he was issuing a decision with reasons at that point. I think he made it very clear that he was not making a decision yet and that he would issue a written decision. So any kind of stray comments he was making, I don't think can be kind of reconstrued into a decision when he made it very clear that that's not what he was doing.
I mean, is it your position that we should await his reasons in order to make an informed appellate decision? Or is it your position, I think you said this in your brief, that it's theoretically possible that he could reverse the magistrate judge's decision and effectively mooting this appeal? Or not mooting it, but as a
I think that is still possible. I think he could issue a decision saying no detention. I think given his comments, that's probably unlikely, but just pure speculation. I think given the fact that he has stated he is going to hold his decision in abeyance until this court acts, I think probably the proper court, I think the court has a couple of options. One of which is obviously to just dismiss, wait for him to issue his decision, and we would be back up here on appeal from that decision if it is a detention decision. Or the court could simply direct him to issue either an indicative ruling or, his actual detention ruling. You could put a timeline on that and say within 24 hours, issue your detention decision and then just decide this case now that we've already briefed all of the issues. So I think those options are available, but what I don't think the court can really do is issue a decision prior to the associate judge's, ruling on the request that was made to him. I think this sort of bleeds into the standard of review, which I do think is for abuse of discretion, because this court has said many times that detention decisions are highly discretionary and within the trial judge's purview. I think Judge Glickman, you said that in the DM case. You said detention determinations is left to the informed discretion of the trial judge. And so it's naturally the sort of thing we would think is highly discretionary because to your question earlier, Judge Beckwith, there's not always going to be a clear yes or clear right or wrong answer in these circumstances.
What about KG treating this as like a sufficiency claim?
So KG did say that. I think KG comes on the heels of a number of decisions. We cite some in our brief: DJ, DM, RDS, JFS, all of which say this is abuse of discretion review. So I think those earlier decisions would control over the panel, even if KG is saying something different. I think.
Is that the government's position that KG is wrong and can't overrule prior decisions?
Well, it's certainly the case that can't overrule prior decisions. I think to the extent it's talking about sufficiency, it's a little unclear to me what exactly that means in this context, because as Judge Glickman pointed out, the determination being made here is a predictive one about whether someone's likely to come back to court or not. That's not really the sort of thing that we normally evaluate for sufficiency of evidence, because it's not like the following events happened. There was evidence that the following events happened, and that therefore someone is guilty of a crime. It's whether there's enough evidence to think that someone is going to do something or not do something in the future. And so I think that's just very difficult to kind of frame in the sufficiency context. But even if you did, sufficiency as normally described is still quite discretionary, in the sense that just any reasonable fact finder needs to have been able to come to that conclusion. You kind of draw all the inferences in the government's favor in that context. So I think then you're just sort of looking at, is there enough evidence that any reasonable trial judge could have concluded detention was
But it
proper?
still boils down to a legal question.
Certainly there's kind of a legal minimum of evidence, and KG was an example of where there wasn't enough legal evidence to reach that legal minimum. So whether you describe that as a sufficiency problem or just the trial court abused its discretion because there wasn't enough evidence to support its decision, I think either way, it's still a pretty discretionary test. And in this case, I think we have a lot of information that suggests that J.R.R. is not likely to appear at future court appearances. We have at least 3 instances where he absconded from home, several of which required the police to return him to home, resulted in 2 separate custody orders by the trial court. He failed to attend school on multiple days and had a disciplinary record at the school as well. He failed to attend 5 different appointments with the court social services.
So we start with a presumption against detention, right? In
Definitely.
the juvenile context. So what about these facts? As a matter of law, if KG is right, says that detention is required because of these things, when the fact is he has never missed a court hearing.
Well, I agree he hasn't missed a court hearing. I would point out that a couple of those court hearings were a day or 2 after the custody order was issued and he was returned by police. So I don't know that you can really.
It seems so attenuated when you're talking about, is detention required? We're talking about, well, maybe he would have missed that day. It doesn't seem like what the council is thinking.
Well, I agree it's a difficult predictive judgment in any case. It certainly can't be the rule that you have to miss court appointments before the court can decide that your detention is necessary, because the way the statute is framed, normally this whole discussion is happening pretty quickly after someone is charged, within a few days. So there wouldn't have been very many court appointments for them to have even appeared at. And so the court is making a necessarily predictive judgment about the future. And in this case, there was a lot of information available to the magistrate judge and to Judge Willoughby that he is not complying with the more lenient conditions that have been imposed on him. He's not charging his GPS monitor, so nobody can find him. He's not abiding by his curfew. There's obviously some concerns around that. And I think it's not unreasonable to conclude that that sort of litany of abscondances and failure to abide by conditions means that some form of detention is necessary to
I guess
secure
I wonder
him.
about that because you have the presumption and you also have all the evidence that Ms. McDonald was talking about, his ties to DC. He's not, there aren't the classic things in adult cases where
Mhm.
we're like, oh, this is a murder case. He's going to spend the rest of his life in prison. And he has a one-way ticket to Argentina or something. Like, you don't have anything like that. You just have a kid who has a diagnosis, who is acting, is very much younger than his actual age, doing the things that kids do. Is that, detention is required?
I think it was reasonable to conclude, or would be if Judge Willoughby is deciding that it was reasonable to impose detention. I mean, what you have here is a 13-year-old kid, obviously has a lot of issues and family issues that he's dealing with, but he's running away from home, being found in abandoned buildings, being picked up by police, using drugs. There's a lot of concerning behavior here, and
Well, that
Ye-
sounds like he's being taught a lesson by being detained.
no. I think all of these are concerns about him running away and not showing up where he's supposed to be. I mean, his appointments with parole officer, that's with court social services. I mean, it's not a court appearance, but it is still a court ordered meeting that he's supposed to be meeting with a probation officer to get the services he needs to help him with rehabilitation. And he has not attended any of those. And so at some point, I think it is reasonable, even if the person hasn't missed a formal court appearance. And again, I would note that 2 of those appearances came on the heels of him being picked up by police and brought home. So I don't think that he can really consider those fully voluntary. But even if you do, I don't think it's an abuse of discretion to say that some form of a detention would be reasonable in these
To
circumstances.
what extent was the court required, or should the court have credited, I believe it was J.R.R.'s counsel who said at the hearing, effectively, we are going to make sure he gets here. Is that something a court can consider or should have considered or given more weight to?
It's certainly not a factor listed in the rules, although those are non-exclusive. The court can consider really anything that bears on someone's likelihood to appear. I don't know that you can really say that counsel is capable of fulfilling that promise, especially if he is running away from home and isn't charging a GPS monitor. I'm not sure how they would know where to get him to bring him to court and ensure that he appears. So I think the court can consider it, but I wouldn't say that it's necessarily of much weight given the circumstances here. I did want to address a couple of other points, Judge Glickman, to your questions about whether even if this GPS condition was imposed improperly, whether he still had to comply with it. I think the answer is certainly yes. So an example of that case, which was a very similar hypothetical to what you just described about a CPO, is the In re Shirley case, which is 28A3rd 506, which involved a protection order. And the defendant said, well, the victim and I agreed that I could come and see her. And so therefore I didn't have to comply with the stay away order, essentially. And the court said, no. Until the court's order is rescinded or overturned on appeal, you are still required to comply with it. And I think that that's exactly the case here.
I mean, that may be the case, but the question is it a violation of the tampering statute? Right?
Yes, because the tampering statute says if you're ordered to.
Well, it doesn't say ordered. It says if you're required.
If you're required, sorry, I apologize. If you're required to wear, well, let me just pull it up so that I'm not just going off of memory. It is unlawful for a person who is required to wear a device while incarcerated or committed, while subject to a protection order, or while on pretrial release, predisposition release, that's what we have here, to intentionally remove or alter, not charge the device. And he was required by the order of the court that he never objected to, he never tried to appeal. This, a condition of supervised release, like a GPS monitoring, is appealable to this court on an emergency basis, and he did not avail himself of that.
Did you make that argument before that he didn't object to it?
We certainly made that argument in our briefs to this court, and we noted that we thought he had forfeited any kind of objection to the GPS monitoring condition. It is surprising to me to think that someone would be ordered to wear a GPS monitor on August 25th. They say on the 27th, when this probable cause hearing happened, he should have no longer been required to wear it. And then he's still wearing it a month later and says, I'm not required to, I never was required to. It just doesn't really make any sense that that they seriously think that he wasn't still required to wear it by
Well,
operation.
so you're basing that on, again, the notion of the court order. But would you agree that as a statutory matter, upon the finding of no probable cause, he should not have been required to wear a GPS device as a condition of release?
No. So I think that the no probable cause finding is essentially a non-entity because it doesn't eliminate the pending charge. There can still be another probable cause hearing if detention is sought again. So I think all of the court's ability to impose conditions of supervised release remain even after a no probable cause finding, just as they were before the probable cause hearing. I mean, the statute clearly says you can impose conditions prior to a probable cause hearing when there's obviously no finding of probable cause yet.
But 2312 says upon a finding of no probable cause, the individual must be released.
Right. So I don't think detention is possible at that point, but I don't think that anything in that says you can't impose conditions on that release. Because you can impose conditions even before the probable cause hearing when you can't impose detention because
But
there's
isn't the GPS sort of a form of detention?
No, it's a condition of supervised release, which can include restrictions on, I mean, if you look at the statutory definitions of what those conditions can include, it can include things like a curfew or requiring someone to remain in a particular area, go to school, things like that. So those are restrictions on liberty in kind of a broad sense, but they're not a form of detention.
I must say, I find it hard to hate to say this, I find it hard to accept the notion that without a probable cause to believe that the person or more, to believe that the person has committed a crime, the court can impose conditions that restrict the person's liberty because there's a case pending against the person.
Well,
That seems to be what you're saying.
yes, and I think the statute explicitly contemplates that
Well, the
because
statute may say it, maybe it says it, maybe it doesn't, I don't know, but I'm not sure it says it clearly enough, but is that constitutional? I mean, you know, you come into court here and I don't like the cut of your jib and I say, well, Mr. Girton, if you want to walk out of this courtroom, you're going to have to wear a GPS monitor.
Well, I think that would be an unusual
Might
circumstance.
be arbitrary, but
Yeah, I think there'd be a lot of problems with that. I think I would still abide by that order if this court gave it until it was
all right,
returned, but
it's a court order and whether you have to abide by it until you can get it changed, that's a separate question.
yeah, so
But I am a little surprised that you think, do you have any case law that supports the notion that a person, even whether it's an adult or a child, for whom there is no probable cause shown,
Mhm.
can still be required to wear a GPS monitor?
so
Or similar restrictions on a person's freedom?
I don't know if I have a case, but I certainly think if you look at the text of 2312, it says that when someone is charged with an offense, the court shall first make a decision about whether detention is appropriate or not. And if not, if the child is ordered released, the judge may impose one or more of the following conditions, and then lists all of them, any other condition reasonably necessary to assure the child's appearance. In that case, the statute doesn't require any probable cause hearing
But
to
that's
occur.
different from a probable cause finding was made and the finding is no probable cause. Isn't that completely different?
I don't think so, Your Honor, because unlike in the adult system, a no probable cause finding doesn't erase the charge. They can still be tried and found responsible for the charge. They can still have another probable cause hearing if detention is sought again. So I don't think it has any kind of preclusive effect. And I don't think there would be any constitutional difference between someone who hasn't yet had a probable cause hearing being ordered to wear a GPS monitor, which is what happened here. The GPS monitor condition was added before any probable cause hearing in this case, versus someone who has the hearing, no probable cause finding, their conditions still remain from before.
So can you tell me how it works? If there's a no probable cause finding in the juvenile context and the petition remains pending, which I think everyone agrees, I've been unable to find anything in the statutory scheme that says this, but again, I'm revealing my ignorance here. But the petition remains pending, the case can still be brought. I mean,
Yes.
how does that work?
If-
Do you have to get a new probable cause? You have to have another probable cause hearing where there is a finding of probable cause?
If you want detention, yes, you would need a new probable cause
Only if you want detention, but otherwise you can go straight to
to trial, yes.
trial.
Yeah.
So in the case where there's no problem, where the judge makes a finding, no probable cause,
Mhm.
but, wear that GPS monitor. If the juvenile says, well, wait a minute, you can't detain me, and there's no probable cause,
Mhm.
because there's no probable cause. I'm ripping off this GPS monitor. Here it is. What are the judge's options at that point, in your view?
So they have certainly violated a condition of their supervised release. I think the court could impose additional conditions of supervised release in that circumstance. That's what is contemplated by.
Like what? Like what, for example?
So in this instance, the judge extended his curfew to 24 hours rather
Well,
than.
suppose he says, I don't think I'm going to obey that extended curfew. Who are you, judge,
Mhm.
to order me to, to tell me what my hours are going to be when there's no probable cause to believe I committed any crime?
So I think then there's two options at that point. Either if the conduct that the person has done is a separate offense, which is what happens here with the GPS monitor, they could be charged with that.
Well, there's a circularity to this when you say that, but all right, I'm listening.
So then the court could decide that there's probable cause on that new charge, which is what happened.
That's
here.
what happened here.
Right, that's exactly what happened here. I think the second option is the court could evaluate whether, well, I guess if there's no probable cause on the initial charge, yeah, maybe that's the only option is.
I mean, I think that what the judge could say is, okay, wise guy, but if you're convicted at trial, well, but I'm a little puzzled by this, I must say.
Yeah, so I agree. It's a little bit of a strange feature of the juvenile system that we have probable cause hearings, but our understanding is that they're really only required if someone is seeking detention. If no one is seeking detention, you don't statutorily have to have a probable cause hearing at any point before trial.
What about your opponent's argument about in reg QB?
So I don't think in reg QB really moves the needle here because all that QB says is that you can't be found to have violated a court order in the sense of the contempt statute. So I think it's really talking about the language of the contempt statute and whether or not a condition of supervised release is a court order. But here we're talking about the GPS tampering statute. And so it's really just a question of whether the GPS monitor was required, as the statute says, as a condition of supervised release, which I think contemplates exactly the circumstance we have here, where someone was released pre-disposition and was found to have tampered with or not charged the device. And that is a separately chargeable offense for which there's probable cause. I don't think that they've really made an argument that the finding of probable cause on the GPS tampering kind of as a factual matter was invalid. It's really just this legal argument, which I'll note that they did not raise below at the probable cause hearing. And they did not raise any problem with the GPS monitoring condition when it was opposed or after the kind of the first probable cause hearing. So I think they forfeited that argument in a multiple different ways. But even independent of that, I think to Judge Glickman's point earlier, the condition was imposed. It was not overturned or vacated by the trial court or this court, so it had to be obeyed, and I think therefore would qualify as required under the GPS monitoring statute. The last point I did want to make, Judge Beckwith, to your earlier question about KG, I think we are in agreement with Ms. McDonald that it uses the word shelter care, but it's really using that term incorrectly. Youth shelter house is a form of detention, not a form of shelter care. Okay. Unless the court has any other questions, we would ask the court to either dismiss, hold this case in abeyance, or summarily affirm. Thank you.
Thank you. Ms. McDonald will give you 3 minutes for rebuttal.
Thank you, Your Honor. I want to start with the standard of review, which is quite clear here that it's for sufficiency of the evidence. The government hasn't cited a single case, even predating KG, that says that review of the satisfaction of the detention criteria is for abuse of discretion. They have cited cases that say in dicta, as we pointed out in our reply in opposition, that the detention determination is discretionary, but I think there's no reason really to think that this is talking about whether the detention criteria in 2310A are met, as opposed to, as we pointed out, it's still clear that courts have detention discretion whether to detain if those criteria are met. And a lot of this language comes, as we've also pointed out in our reply in opposition, from a juvenile scheme before the council enacted detention criteria. And now that these criteria exist, as KG makes clear, it's a sufficiency question. And the government's argument that you can't do sufficiency on a predictive matter really falls apart in analogy to the adult context. And so KG relies on Blackson. In the adult context, detention decisions are reviewed for sufficiency of the evidence. Blackson is 897 A second 187. Detention is also a predictive question in the adult context, but there's absolutely no question that that is a question of sufficiency of the evidence, a question of law that the government must establish by clear and convincing evidence. That is the case here. Whether detention is required is not a discretionary determination.
Did KG make the point about clear and convincing evidence, or where have we said that?
So I think that this court's decision in DM, which is 254 A third 398, is talking about clear and convincing evidence. Clear and convincing evidence, again, is the standard in the adult context. So I think KG is saying, like, there's no reason to evaluate the criteria for detention in terms of the standard of review and the standard of proof differently than in the adult context. In the adult context, clear and convincing evidence is baked into the statute, but it was originally a judicially created rule that comes from Lynch and from Salerno before that.
Your point that it's not appropriate to talk about discretion or abuse of discretion when the issue is whether the criteria for detention have been met. That has a lot of force to it, but this may be just a question of, well, we're using the wrong term to get at what we're talking about, which is that just as in when we review whether evidence is sufficient in other contexts, we give a great deal of deference to the fact finder's evaluation of the evidence and what it signifies. And that may be a better way to put this than speaking in terms of a standard of review, abuse of discretion. But it seems like it gets to the same point, which is that the government is arguing that on the evidence here, it was not the fact finder, the judge, did not unreasonably find that there was sufficient evidence to justify detention. Because it's how the fact finder views the facts of record. And for you to prevail, government's point is, we have to find that it was unreasonable for the judge to think that the evidence before the court raised a serious concern about whether this particular juvenile would appear in court at the proper time and place. That's really, I guess, probably I shouldn't have said abuse of discretion for that reason, but it comes down, I think, to the same basic point. And I don't know, why it's so unreasonable for Judge Willoughby to have been of the view, we may be positing since he's left things up in the air a little bit, but to be of the view that that there is a serious concern here about this juvenile. Other fact finders might come out differently, but there certainly are a lot of concerning features of J.R.'s behavior in this case that suggest how confident can we be that J.R. will come to court.
And the statute is what makes clear how confident you have to be. The legislature has explicitly and intentionally limited the bases for detaining children before they've been adjudicated delinquent. And the legislature says, unless detention is required to secure the child's presence at the next court hearing, they shall not be detained before adjudication. That's the standard that anyone reviewing this determination has to establish, and the evidence here is just insufficient to meet that. And I think a lot of the things the government talks about sound in J.R.'s needs, the need for rehabilitation. Those are things that are addressed after the disposition stage. That's what disposition is for.
The two words in the statute that are key, one of them was required.
Required.
And was the other two assure?
To secure the child's presence at the next court hearing.
So how much breadth is there in the word secure?
I think we know, again, from KG that there's not much breadth. The legislature has explicitly narrowed the detention criteria in light of the recognized harms of detention to children, in light of children's due process rights, and in light of the council's manifest desire to keep children in the community whenever possible. When this court was construing 2310A1 in KG, the court said we must construe it in terms of those purposes and those motivations by the legislature. And this is true here.
It strikes me that on the facts of this case, when we see the kinds of stuff that J.R. was getting into, staying in an abandoned building and all the stuff that they point to, the notion that he's going to be harmed by being held in a shelter house for a short period of time rather than left to roam the streets and so forth as he was, strikes me as a little bit, it's pushing the envelope a little bit.
And that's why I had the point about detention is about risk, not about needs, right? We can all think that JR has needs, but the court's ability to address those needs comes from the disposition. Before JR has been adjudicated delinquent, and now especially there are serious questions about probable cause as to JR, but setting those aside, before he's been adjudicated delinquent, the court doesn't look at needs in addressing conditions of release or detention. Both release conditions and detention must be motivated by one of two risks: a risk to the person or property of others, or a risk that the child won't appear in court. And JR, who is 13, who has at least 2 diagnoses, who is facing charges that are very much not serious, and who has always appeared in court, does not present a high risk of those things, and those are the only things that matter at the pre-adjudication stage. I want to just make one very brief point about the probable cause point, which is that whatever the government's arguments about the court's authority to impose conditions of release before a probable cause finding, the probable cause finding matters. The child must at that point be conceived of absolutely as innocent. There's nothing that gives the government multiple abilities to establish probable cause. And the only reason that the conditions existed in the first place was because of this agreement between the child and the court, that the child could be subject to detention. Those conditions could be imposed when JR was potentially detainable. Now there is a judicial finding that he is not detainable. And after that point, those conditions became a legal nullity. They could not have been required under the tampering statute. And I think the government's analogy to contempt is really an apposite, partly because of QB. In contempt, it doesn't matter if the order was lawful, but I think the tampering statute has to be construed as a lawful requirement. In other statutory contexts, such as APO, the legislature specifies when something doesn't have to be lawful. APO applies whether or not the arrest was lawful. So I think the tampering statute has to be construed for there to be a lawful requirement that J.R. abide by a GPS monitoring requirement. That did not exist here. There is no probable cause to detain him, and there is no statutory basis to detain him.
Well, the
He
government
must be
argues that
released.
the statute allows it even if detention is off the table.
That the statute allows release conditions.
Yeah.
I think they've argued that the
including
statute
specifically.
allows release conditions when detention is potentially still on the table. They're saying it allows release conditions before there's been a probable cause finding, but they don't point to anything in the statute. And I think Your Honor, as Your Honor points out, there are serious constitutional concerns with construing anything to mean that after there's been a finding of no probable cause, when the child isn't detainable, that there could still be release conditions. There's a huge difference between a world where the child is potentially detainable and so can be subject to conditions that are, withdrawn by detaining the child, and a world where the child isn't detainable.
So putting aside the constitutional concerns for a moment, which I realize is a crazy thing to say, but under the statute and under the juvenile scheme, upon a no probable cause finding, given that the petition remains alive and the juvenile could be brought to trial as the next proceeding, I guess, if the court deems it a risk that the juvenile will not appear, I guess, does the court proceed to schedule trial at that point, or can they? And if they determine that the juvenile is likely to not appear for trial, there's no recourse in terms of release conditions at that point, right? That's your position.
No recourse for release conditions, but the posture would become similar to like the issuance of a material witness warrant. So just as the court can order witnesses to show up in court when the court doesn't have probable cause over those witnesses, the child would be in the same posture. They could be ordered to appear in court, and like a material witness, or that could be enforced. They could be brought into court. But once there's a finding of no probable cause, that is the posture the court is in with the child. A material witness, the court isn't saying, you have to go to school, those kinds of things. The same is true of the relationship between child and court once there is a finding of no probable cause on the petition.
Am I mistaken? I just don't remember this from years in practice. Can a material witness be detained? I have this vague recollection that the court can detain a material witness, but I could be completely wrong about that.
I mean, my understanding is they could be sort of detained in the course of getting them to court. They couldn't be sent to jail.
Suppose the material witness says, if you don't detain me, I'm out of here.
I mean, so they could be sent to jail if potentially, maybe, if they're saying I won't come to court. But we're in a world where J.R. is never saying I won't come to court. Like everything that he's coming to court, there's absolutely no reason to think. And we'd be in an entirely different world if, he were ordered to come into court. He was not obeying with police trying, that's just not even hypothetically the world we're in. And there's no suggestion that we'll be in that world because of J.R.'s demonstrated record of coming to court, even when the consequences of coming to court are really high. So for these reasons, we ask the court to summarily reverse and order that J.R. be released. Thank you.
Thank you very much. Thank you to both sides for your briefing and your arguments today. We will issue a decision in this case shortly within statutory requirement. We are adjourned.
All right.